Okay, thank you, Aviva. It is my pleasure to introduce uh, three of my colleagues at my firm, um, who are each experts in this area on the issue of divorce and family law, and specifically discovery. Um, Elizabeth Lazara currently serves as our firm's co-chair of the Divorce and Family Law Practice Group. She has over 30 years' experience representing clients in all phases of divorce and family law, and devotes a substantial portion of her time to representing clients on children's issues as well. She's been recognized by Illinois leading lawyers for family law since 2003 and by Best Lawyers in America for Family Law since 2019. Michael Zaslavsky represents clients in divorce and family matters. He has worked with many prominent business executives and high-profile professional athletes in various domestic relations matters. And he's also tried complex issues involving financial matters, real estate disputes, and child custody issues. In addition, over the past 35 years, he's been frequently appointed as guardian ad litem in contested custody cases. Michael's been included for many years in Best Lawyers in America, Illinois Leading Lawyers, and Super Lawyers. And our third speaker is Sarah Imam, who is an associate in our firm's divorce and family law practice. She counsels clients during all stages of divorce and family law conflicts. She has extensive experience in pre and post dissolution of marriage cases and also represents clients in guardianship proceedings. And with that, I turn the matter over to you three. Good luck.
Nate, thank you very much. If I may take the lead here, let me first thank the Decalogue Society for allowing us to join you for your continuing legal education meetings. We are proud to participate in this, and we hope that whatever we tell you today will be beneficial to you in your practice in the family law arena. Elizabeth, Sarah, and I are here today to discuss the discovery process in family law matters. For purposes of our discussion, family law matters will include all aspects of family law, including dissolution of marriage proceedings, custody and allocation of parental rights proceedings, domestic violence, and orders of protection, all of which will be afforded the same discovery processes available when participating in those types of actions. Bear in mind, the discovery process is often very frustrating, time-consuming, and of a great expense to your respective clients. However, it is necessary to go through this process to properly prepare a case for settlement, which I think is really the optimal goal. And in the event a case cannot be settled, trial is necessary. Your discovery will come in handy, necessary, and probably mandated by your malpractice carrier. And that's a consideration because if you're going to trial, I really think that it's mandatory to have with you all the discovery materials, all the necessary and requisite financial information to be able to properly proceed to trial. There are different areas of the Illinois divorce process that have a significant impact on the results of a divorce. In my opinion, discovery is the single most important of those aspects because it does prepare you for settlement and or trial. You learn a lot about your client during the discovery process. You learn a lot about your opponent during the discovery process. And you also coincidentally learn a lot about your opposing counsel during a divorce, during the discovery process. You learn how they act, how they respond, and how compliant they may be with the process, as well as court orders that are entered in conjunction with the process. In a nutshell, discovery is supposed to be used by both sides to gather evidence, to ensure that each party has access to the same information, both financial and otherwise. To negotiate a fair settlement, you have to have equal access to this information, because ultimately, you're going to probably be required to prepare a balance sheet so that you each know what the other side has and what you're going to negotiate in terms of resolving the case. It's a legal process, and as such, the discovery process is governed by the rules of the Illinois Code of Civil Procedure, the Supreme Court rules, and the local court rules of whatever circuit you happen to be sitting in trying this case. Failure to adhere to these rules is sanctionable. Courts can issue sanctions, which Sarah will get into about what the potential sanctions are, but sanctions can be imposed for all discovery violations if requested and the court sees fit to grant those sanctions. The areas of discovery, their challenges and their importances, the challenges of each, as well as their enforceability, will be addressed by Sarah in her presentation. They'll include written discovery, oral discovery, the issuance of subpoenas, and requests to admit facts or genuineness of documents. The one significant discovery tool, which I think is overlooked, underrated, and not often used, is the request to admit facts and genuineness of documents. It oftentimes can take away a lot of issues because they're resolved through the admission of facts or failure to comply with the request to admit. Absent failure to comply within the statutory time period, those facts that are requested to be admitted and are not denied will be deemed admitted. So I think I have to urge you, take a careful look at Supreme Court Rule 216, which governs the aspect. It should be read and familiarized because it's a tool that I have often used. I believe many other lawyers have used in order to narrow the issues and to get clients to be faced with certain admissions that they wouldn't want to ordinarily take and make. The role in discovery and family law should focus on these issues. You should obtain full access to all information. That information will be contained in Sarah's presentation as far as financial matters, including bank statements, employment records, and any other records that would indicate either asset acquisition, income information, as well as liabilities and debts which exist. Utilization of discovery to promote settlement is something that everybody ought to consider. The identities of all assets and liabilities will further promote settlement because it should narrow the issues and should make each party aware that they have more to lose than they have to gain by going to trial. In custody cases, to investigate and ascertain what is in the best interests of the children, which is the primary criteria, discovery is often required in terms of depositions and other other professionals which may have rendered opinions with respect to the best interests of the children. Please remind yourself and be reminded frequently that family law matters are inherently personal. And as such, parties are often reluctant to disclose personal information. I think at the onset of a representation of a potential client, you have to explain to them the discovery process so they understand that we're not just asking personal questions for the sake of asking them. We're asking personal questions because we will have an obligation to disclose the information at some point in time during the litigation. It's uncomfortable, it's invasive, but it's part of the process, and that's just a function of the litigation in the family law courts. Remember, each case is different. Each case is based upon its own facts. The tools that we discussed throughout this presentation today may not apply to every case. The standard forms, which Miss Imam is going to show you, they're standard forms. Each one should be contoured to the specific facts of your case. There are going to be things that you are going to have to add to the requests for production of documents. Certain interrogatories which will be necessary to be included in the standard matrimonial interrogatories. There will also be standard things that should be removed because they may not be relevant. If the parties don't own any real estate, there's no need to go through the questions and answers on the real estate asset and the information that you may want to know about that asset. Same thing with employment. If somebody is not employed, you don't have to ask where they're working, how much they're making, what their hours are, etc. You may want to know their last employment or their prospective employment, but I don't think that those specific questions are contained in the standard matrimonial interrogatories. So they're going to have to be tailored to fit your needs. Sarah's going to begin this discussion on the steps of discovery and how best to proceed. Elizabeth, at the conclusion of Sarah's presentation, will discuss the best practices aspect of this presentation and give us the benefit of her many years of experience, competence, and expertise, and some real life success stories and problems which she may have encountered throughout the discovery process. After we're done, feel free to ask questions. I think it would probably be most beneficial if we held off on any questions and answers until the conclusion of the presentation, because I think you'll find that many of the questions that you want to ask will be answered throughout this presentation. So we're happy to answer them when you're done. If anything comes up in the interim that you feel we haven't addressed or you'd like more specifics on, please put it in the chat. We're going to monitor the chat and we'll be happy to address those questions as they come up. So again, thank you to the Decalogue Society. Thank you to each and every one of you for giving us your lunch hour today, and we hope it proves worthwhile to you. I'd like you to meet Sarah Imam at this point. And as Nate has given such a wonderful introduction of her, I'll let Sarah take this away.
Hi, thank you so much, Michael. Good morning, everyone. I will be discussing really the stages of discovery. As a preliminary matter, when a family law case begins, discovery does not start immediately with subpoenas and depositions. It starts with information gathering. So what we typically do in our practice, when a client has retained us to represent them, we will send them a document called a marital information form. And I'm presuming that we're representing someone in a divorce or dissolution of marriage action. And what this form does is it helps us identify key issues early on. Things like, does our client own property? Does our client have investment accounts? Do they have bank accounts? Any retirement accounts? It really will help us set the foundation for everything that's going to follow. And it really puts us in a great position to fill out our first preliminary required disclosure, which is the financial affidavit. I've included a copy of the financial affidavit here on the PowerPoint. And if I go to the next page, you'll see a bit more of it. The financial affidavit is a mandatory required disclosure. The form comes from the Illinois Supreme Court. It is a standardized form across, I would say, the majority of courts in Illinois. It is a critical early document because it provides both sides a clear snapshot of each party's income, their assets, debts, expenses. And at this stage, when we're preparing it, it does require a great deal of collaboration with your client because they might not have really thought about their monthly income. What does it really look like? Maybe your client earns overtime compensation, but it's not consistent. Maybe your client just moved into a new apartment and doesn't have utility expenses yet, and they don't know what those expenses are going to be. And it's important to have a very full and complete disclosure and picture of what your client's regular monthly expenses are on their financial affidavit. And each of the collar courts or circuit courts within Illinois have special requirements for the financial affidavit, because it is, as I've said, a required mandatory disclosure. For example, the majority of our cases are between Cook County, Lake County, and DuPage. In Cook County, you're required to tender your complete financial affidavit within 30 days of filing your original petition in service of the same. And in Lake County, the courts often utilize a 218 case management order, which sets all of the required discovery disclosures and deadlines that you're going to have to comply with. And once we tender a financial affidavit, we are able to pursue additional written discovery. And written discovery will include, several familiar tools to, I think, everyone here under this Illinois Supreme Court rules, specifically rules 213 to 216. We often start with our Illinois Supreme Court Rule 213 standard matrimonial interrogatories. The Illinois Supreme Court has set up sort of special categories for interrogatories to exceed the normal 30 request limit. So our standard matrimonial interrogatories are very specifically tailored and designed to get all of the information that would be relevant in a divorce action, like employment, ownership of property, if you're claiming dissipation, if third parties have expended funds on your behalf. And a key point to remember with interrogatories is if your opposing counsel is to alter the standard form, then it's no longer contained within that special category under the Illinois Supreme Court rule. So I would implore upon us all to keep an eye out for any non-compliant or overreaching questions that aren't contained within our standard form. Then we often issue, along with the Illinois Supreme Court Rule 213 request, a 214, pursuant to Illinois Supreme Court Rule 214, request for production of documents. This is where we obtain financial records, communications, and supporting documents that either prove or disprove certain claims in a divorce action. They're typically standardized. I would say that in most cases, our discovery requests look really similar. And that's because we often are requesting employment information, paychecks, tax returns. If a party owns a property, we're trying to, be in receipt of documents relative to property that they own. But again, it's very important to understand your client's background, your client's objectives, because the discovery that we issue in a case where one party has no access to financial information and is maybe even a stay-at-home parent, or has been out of the workforce for a period of several years, is going to look very different from the discovery requests that we would commonly issue, or maybe not even issue, in a case where it is a very short-term marriage. A couple may have been married for only 1 year. Maybe they're young people. They don't have retirement assets. They don't own any property jointly. There would be no need to really go on any kind of fishing expedition to get more documents. We want to keep our discovery requests very, very tailored to our client's goals and strategy. Not every case is going to require the same level of, not to say detail, but of just sheer volume of what it is that we're trying to discover. Again, practitioners often ask for similar requests. Michael did touch on a request for admission of facts, which I would agree is a very underused discovery tool. Michael and I recently, we were discussing a case where, for example, if you're prosecuting a bigamy case, how are you going to prove that an individual was married to two people at the same time? That would be a great tool to use the request for admission of facts, that they were, when was the date of your first marriage? When is the date of your second marriage? And one of the requests can be that you were married to both individuals at the same time. And you should always ask yourself, how is this admission going to help my client? And at the same time, if you're on the receiving end of requests to admit facts, you have to be very careful about timeliness of your response, because any request to admit facts that goes unresponded to is deemed as admitted under the Illinois Supreme Court rules. I would say that a lot of the discovery requests can receive quite a bit of pushback from your own client. And that's because divorce and family law are inherently very personal and very sensitive situations that a person is going through in their life. They might not really understand that your obligation to respond to discovery is continuous and is ongoing. We have a duty to seasonably supplement all discovery. Say, for example, a case is filed and discovery is issued and it's responded to, and the case is still pending 10 months later. All of the discovery that you've previously responded to is now, it's not reliable. It could be moot. Your circumstances may have changed. Say your client now has a new job and is receiving different income. You have a duty to seasonably supplement and provide the opposing side copies of your pay stubs, if you have an employment contract, your employment contract, any different perquisites or benefits, or if your client has now moved and has different kinds of utility expenses, this is something that you'd more likely than not want to reflect on a financial affidavit or an updated financial affidavit. Another great discovery tool are subpoenas. Subpoenas are a very powerful tool. We issue them often to be directed towards financial institutions, employers, or even third parties like family members who might have relevant information. I'll speak in the context of financial institutions. So we often subpoena financial institutions if really the case warrants it. If there is a case that is for example, if your client is a C-suite executive, or if your opposing party is a C-suite executive, then if there's significant assets or significant retirement assets, it's a great tool to obtain that information and obtain those records in a full and complete manner. There are privacy concerns as it relates to subpoenas when you're dealing with sensitive financial or personal data. It's important to balance relevance against a level of intrusion. You have to always ask yourself, how is this information going to be relevant to the issues of the case versus my client wants to know this, therefore I'm going to subpoena it. If the information requested in a subpoena is overly broad or personal, it's important to consider a protective order to safeguard your client's privacy while still complying with discovery obligations. Another tool that we utilize in written discovery would be oral depositions. Depositions are not necessary in every family law case. I say this because they're time consuming and they are expensive, but they can be extremely valuable in complex or high conflict cases. You might pursue a deposition when credibility is central or when you really need to pin down an inconsistent statement. So this can go hand in hand with a request to admit facts or a request to admit genuineness of documents. Strategically, it's important to prepare your client thoroughly for a deposition. This would include reviewing key documents and practicing difficult questions, but also managing their emotions. And I say this because depositions can be stressful, especially in emotionally charged cases. It's important to remind your client to stay calm, be concise, and be truthful. Typically what we do, if we're sending out a notice for deposition to an opposing party, we will include a rider, and in the rider will request documents. Maybe their discovery production was incomplete and there's still outstanding documents that we need to review. It would be a great place to ask for it on a rider. We often have a number of meetings with our clients ahead of a deposition to really thoroughly prepare them. We'll run them through what we anticipate questions to be, and it's a great opportunity to really gather information. It is an information gathering tool. And so I would recommend a deposition in cases that would require one. Another tool is experts. We utilize experts frequently in cases that would warrant them. There are a number of different kinds of experts, all of which you are required to disclose pursuant to Illinois Supreme Court Rule 213F, which is your witness disclosures. These are often part and parcel of a Illinois Supreme Court Rule 218 case management order. The court will set deadlines for all stages of discovery, and witness disclosures are certainly one of them. Often we'll retain a financial expert, perhaps somebody who can appraise a property. We will disclose a property appraiser if the value of, for example, a marital residence is at dispute or is disputed. We would retain an appraiser. They'll conduct their appraisal, and to ensure that the report of the appraiser gets into evidence, we would have disclosed them accordingly and appropriately. In cases that involve children, there are a number of different types of custody evaluators pursuant to not only the Illinois Supreme Court rules, but the Illinois Marriage and Dissolution of Marriage Act. The first one would be a guardian ad litem. This is an attorney appointed by the court to act as the quote unquote eyes and ears of the court and investigate the best interests of the children. Interestingly enough, we're in the presence of a guardian ad litem. Michael Zabslavsky, my colleague, is the guardian ad litem. And if you have any questions about GAL work, I'm sure he'd be happy to answer them. Another kind of evaluation that's often done is pursuant to Illinois Supreme Court Rule 215. This is a mental and physical examination of a party only when a party's mental health is at issue. If there's an allegation that a party suffers from a mental defect and that party denies it, then mental state is at issue and you could move for that kind of evaluation. It's a discovery tool in domestic relations. It's relevant if a party has a mental condition that could impact their ability to parent a child. Then we have, pursuant to the IMDMA, the Illinois Marriage and Dissolution of Marriage Act, we have 604B and C evaluations, which focus specifically on the best interests of the child. Pursuant to 604B, 60410B, it's a court-appointed evaluator if there's a motion for it, and then 60410C is similar, but it's conducted by, it's an evaluation by a party's retained professional. I would encourage you to be mindful about your communications with experts because certain communications with them might not be privileged. I would say always assume that what you put in writing to an expert could end up being discoverable. It's also important to prepare for cross-examination of an expert early. The best time to plan for your cross is when you're reviewing your expert's initial report, and certainly not the night before a hearing on the expert's report. We often use expert reports to aid in settlement discussions. I think a majority of family law cases conclude by way of settlement and not by way of trial, but all of the discovery that I've walked us through now is you always, if a case is high conflict, keep the idea of trial always in the back of your mind because you have to be prepared accordingly. And a lot of discovery is really, if you don't ask for it, you're not going to receive it. So your discovery has to be very focused and directed on your client's goals, and you have to strategize very early on to achieve those goals. Next, I'll talk on common discovery challenges. I would say one of the biggest day-to-day challenges in family law discovery is non-compliance. And it's twofold. We often deal with clients who are defensive and reluctant to provide documents. They might not understand that withholding information is going to hurt their case more than it helps their case. And it's important to remind clients that they have that ongoing duty to supplement their disclosures. Many clients think that discovery is or should be, because it's tedious and it can be frustrating, a one-time event, but it is not a one-time event. Unfortunately, some cases can take over a year, if not years, to find a conclusion, just depending on their complexity and obviously the court's availability if it's high conflict and there's many pleadings going back and forth and the need for court intervention. So what you've produced 8 months ago might be totally irrelevant to the current financial picture or current picture of the case. It's also difficult when your opposing party is non-compliant, when the other side provides incomplete responses. There is a procedure that we can go through. That would be requests for discovery compliance pursuant to Illinois Supreme Court Rule 201K. You have to avail yourself to a 201K conference if one is required. If you represent a client who has no access to financial information and your opposing party simply does not want to produce the required information, and then your client has completely unequal access to information, the judicial reaction to that, might very well be severe. After we've issued a 201K correspondence, I would say certainly do not hesitate to file a motion to compel discovery and for discovery sanctions, because it's going to protect your client's rights to obtain that information, and you may very well obtain sanctions pursuant to Illinois Supreme Court Rule 219C. These sanctions include, but are not limited to, barring the opposing party from making a claim, maintaining a claim for certain relief, might bar them from testifying about a particular issue if discovery was relevant to that issue, and it can grant you an award of attorney's fees in favor of your client. Especially keep in mind with these 218 case management orders, this is setting deadlines for your discovery compliance. And in situations where those dates are not met and it's been a significant delay to obtain discovery, you're entitled to file a petition for rule to show cause. You can be found in contempt of court. The court might order you to purge your contempt by immediately tendering documents and including paying attorney's fees to the opposing party. And of course, some judges are particularly strict about discovery compliance. I would say know your judge's preferences, because some have very little patience for gamesmanship. And there's often, multiple spectrums of overuse of discovery. I think we've all seen cases where discovery becomes excessive and more utilized as a tactic than a necessity to obtain relevant information. 201K conferences are a helpful tool to resolve disputes prior to court intervention, and you should avoid unnecessary or duplicative requests, because every document request and interrogatory really should serve a specific purpose. And next would be, keep in mind confidentiality. Use protective orders to limit the use and disclosure of sensitive materials. You should consider redacting sensitive information, and it might be appropriate to seal records if private information does not need to be part of the public record. You can always incorporate documents by reference only without actually filing something in as an exhibit to your petition. And finally, ethics. Managing your client's expectations is key. Clients often think about discovery as finding a smoking gun, but in family law, it's mainly about assembling a full and fair financial picture. You should avoid discovery abuses like issuing unnecessary subpoenas or demanding irrelevant personal information. And remember that discovery in family law matters especially should not be used as a tool for harassment or intimidation, especially in cases involving domestic violence or power imbalances. So in short, it's a balancing act between thoroughness and proportionality. And so I would implore upon all of you to handle discovery strategically, not only to strengthen your case, but to build credibility with the court.
Sarah, thank you so very much. That was very informative. And I don't know if we want to, Elizabeth, before you start, Mr. Bergman has asked 2 questions here. Should we hold off on those till the end? I'm sorry, you're
Elizabeth,
on.
you're on mute.
I was saying you can address them now if you'd like.
Okay, Mr. Bergman?
So the question was, in a heated divorce, what happens if one of the parties is hiding assets in a trust overseas and does not disclose all financial assets in the financial disclosure affidavit? What tools can be used to uncover hidden assets? Michael, you want to address that, or you want me to?
You can go ahead if you'd like, and I'll certainly comment if I have anything to add.
It's not uncommon in divorce cases where there is an imbalance in control over financial assets. And it's not uncommon for us to have the party who doesn't know anything. You know, we also have the party on occasion who knows everything and hasn't shared any information. The goal in a divorce case is to balance the knowledge. And how do we go about that? A few years ago, when the Illinois Supreme Court modified our financial affidavit, it imposed a penalty provision meant to penalize people for falsifying financial affidavits, because historically we've seen false statements all the time. So, you know, the court is aware that people are hiding assets and not providing complete information. The modification on the financial affidavit and establishing punitive measures for people who falsify affidavits was the first step in compelling people to be more truthful. But what happens when we have more sophisticated estates, as we get financial experts involved, we get forensic individuals who scour financial reporting, bank statements, tax returns, following the bouncing dime. Where's the money coming in and where is it going out? So trying to find hidden assets is a very complicated process, but we definitely have the resources, not only the subpoena power, but engaging counsel and outside jurisdictions to issue local subpoenas so that we can track down financial information. But it all starts with that forensic evaluation, with getting basic information about accounts, about using the subpoena power to compile statements, subpoenaing financial professionals, accountants and planners who might have more sophisticated documents, and then going through those documents to find loopholes and gaps in the reporting. And once we find those, we engage our forensic experts to identify where that money might be and start issuing our subpoena powers in United States and outside jurisdictions. So it's not an uncomplicated process. For those of us like me who like numbers, it's very engaging. I love to find, you know, that number and that aha moment. So, you know, we do see it, but what we've seen, especially in the last several years, is that people are being more truthful in their financial affidavits, because they know that the court will penalize them if there are undisclosed assets, and we will find them. So the court's been helpful in that regard.
And if I may add just one additional thing, Mr. Bergman, just so you know, because I think it's pretty common that people have this question. Oftentimes you have to back into that hidden trust. If it's not disclosed, a forensic accountant or a forensic expert should be able to review all financial documents in order to track it down and find Elizabeth's aha moment. Because if there's a check written and a deposit made, a withdrawal made, oftentimes that's going to be your aha moment, and then decide how you figure out where that money went. And it's a tracing exercise. You have to figure out how it got from one place to another, unless it's cash. If it's cash, it's a different story. that's going to involve a whole new set of problems and protocols.
And you know, I don't think that we have time today, but the issue of Bitcoin, and intangible assets is an entirely different animal and for a different conversation, but it's definitely made our job in tracing, more complicated. But you know, we're legislating, to uncover those, things, and hopefully we'll find some answers, you know, fairly quickly in regards to discovering some of those intangible assets. The second question, and I don't want to veer too far off of our loop here, is when we're hiring experts, do we engage them personally? Do our clients engage them? How do we protect attorney-client privilege? Most of the time, we as attorneys are engaging experts on behalf of our clients so that we protect that attorney-client relationship. And any work we do with those experts is a part of our work product and not discoverable. So we try to be very careful. Sometimes we engage experts and we get the answer we don't want to hear. You know, oftentimes we find new things, but it's not uncommon for us to say, gosh, I didn't want that appraisal report. I don't want to have to disclose that. So before we disclose that expert as one of our witnesses under 213, we want to make sure that it's something that is, we want disclosed. So part of that is protecting the attorney-client privilege by engaging those experts ourselves. But let me talk to you a little bit about best practices. I've been practicing for almost 33 years exclusively in family law. And what I've learned over the course of that time is it's important to be the most prepared person in the room. Start your discovery early. Let your clients know how to engage in the discovery process and what their obligation is going to be in that regard. It's not uncommon in a divorce practice for someone to come to you and say, I never had access to any information. I don't know where our accounts are located. I don't know where our tax returns are. Our job is the benefit of hindsight. We know where all that information is. If you see something coming in the mail, just get that one piece of paper. If you have an older tax return, we can start there. If you know the name of your tax preparer, we'll reach out to them, because people are afraid and they feel vulnerable. And so it's my job to make sure that I can make them feel comfortable that we'll find information. And part of the obligation in the financial affidavit process is people are compelled to disclose. You must disclose with your financial affidavit supporting documents that include 2 years worth of tax returns and pay stubs. That's the initial threshold, and judges are enforcing it. In every courtroom in the state of Illinois, they are enforcing the compulsion to produce records. You can't say no. And we will find it. We'll get that information, and that's where we start. That's not where we finish. So once we receive tax returns, I can look through schedules and find out if there have been investment accounts in the past. And then we can start using our subpoena powers to investigate those accounts to see if accounts still exist. Did somebody liquidate a retirement asset unknowingly? Were taxes paid on that liquidation? Take a look at the schedules. So those tax returns are very telling. So part of that best practice is to be vigilant. Don't assume someone's given you everything. Don't assume that your client has all the information and her saying, I don't have any retirement accounts is the end of the story. It's our job to be vigilant and to go through the documents when we get them and make sure that we're covering all of our bases. We also have to be respectful of the process. If a client comes in and says, 11 years ago, I gave him $10,000 from my Aunt Janie's trust to buy a house. Well, it's very unlikely that a court is going to go back 10 years and find that money, that $10,000 that was commingled into a joint asset. Let's be truthful with our clients about that. It's very unlikely we're going to recover that $10,000. However, we have the ability in Illinois, because we're not a 50-50 state. Illinois is a state of equity, not equality. If it's equitable, to get your $10,000 back, we'll try. But we have to have the clients focus on the now. On, what's happening right now, or at least within the last 5 years. That's what our dissipation statute says. And let's focus on that. And let's try to get the best dollars within that 10-year period. Focus on discovery that's meaningful, that's going to result in something that's relevant to the case. It's not meaningful to subpoena a new girlfriend unless there's money that's going out being expended on the new girlfriend. And we have to make sure that money is worthwhile. If it's, $30 at the Denny's, do you want to spend, $400 on attorney's fees to chase after that $30 charge? Probably not. So, it's really important for clients to be a part of the discovery process from the very beginning, to know what we're looking for and to know where it's going to lead us. And then, what I've learned is that it's really important to follow through. You can start at the beginning really strong by issuing all your discovery and then move on to the next file on your desk and forget about your discovery, forget about responses and when things are due, forget about whether you got a response to a subpoena or opposing counsel issued a subpoena and you lost your response. It's really critical to have a calendar, to have an inventory of discovery. When was it issued? When did we get responses? When did we issue a 201K demand? Do we need a motion to compel? When's the last time I called opposing counsel to get records? It's really important to have this inventory, to have a calendar of discovery so that we're not faced with a 218 case management order and a deadline a week from now when we haven't done our job in collecting documents timely. So it's really important to me in my practice. We're type A, here we are, we've got to follow up with all of those records to make sure, for malpractice reasons also, that we're doing our job following those schedules. And some courts are more pressing about discovery than others. Cook County, it takes a long time to get in front of a judge in Cook County. And so attorneys, we don't feel as pressed to push those discovery compliance issues. In other counties, there's case management orders entered 90 days after a case is filed, and your dates go out for the next year and a half, and you have a trial date within 90 days. So their dates, there's very little wiggle room to get around those compliance dates, and you must know them and which county you're in. So it's really important to know your jurisdiction, what's the term, KYP, right? Know your personnel. Who are you what court are you in, and what are the requirements within that courtroom? What are the standing orders regarding discovery in front of a judge? When do they want to hear a motion to compel, and when are they entering 218 conferences? But then know your opposing counsel. We've been doing this for a very long time between Michael and I, and now Sarah. We know a lot of the people who are engaging in the practice within our area. And we're able to pick up the phone and say, listen, our responses are due tomorrow. Can we have another week? We all have the flexibility to do that, but don't lose track of what your goals are and what your deadlines are, because we have trial deadlines, we have discovery closure deadlines, and as friendly as you are with your opposing counsel, the court's a different story. So you don't want to be backed up against a deadline in terms of discovery. So for my best practices, keep a discovery inventory from the very beginning. Your financial affidavits due 30 days after your case is filed. Create a list. When did I produce my financial affidavit? When did I get theirs? When did I issue written discovery, request to produce an interrogatories? When did I get theirs? When did we respond? When did we do our 201K demands? Stay on top of it, because it just makes your life easier. Your clients are happier, and they're in the loop. And I think, Sarah, I don't know if it was Sarah or Michael that mentioned that clients hate discovery. Hate. I just gave you that. I gave you those. No, it was 6 months ago. You have to tell them in the beginning. And until your case is over, we're going to need updates. Send me your pay stubs every now and then, keep the flow of information going, because then we're not chasing for records. Things being electronic now make it a lot easier because clients can just go online and download a document. They don't have to run to the bank and ask for statements so much anymore. But it's still tedious. So, the more we communicate with our clients about discovery, the less scary it is. But finally, I do have a couple of stories. We've got a few more minutes. As I said, we always like to be the most prepared in the room. When we have our discovery in place and we sit at a pretrial and the judge asks us questions about the comments we're making, it's helpful to say, with my discovery inventory, Judge, I gave them this document on such and such a day. They've had it for, 3 months. That this isn't a surprise. So those are always success stories, and the clients always like to hear the favorable outcomes. Some discovery failures. One of our problems in the past, and I'm the first to admit that I'm a very poor delegator, is when I delegate something, I'm responsible. My staff or the people that work for me it's not their responsibility when I delegate. I had a case, I went to trial, and I thought I had a discovery deposition transcript, but it wasn't ordered. And so a week before, we didn't have what we needed. The client was asking for it so she could prepare, and we were behind the 8 ball, and who pays, for those transcripts. Another story, the client, was tardy in updating her financial affidavit. And there's rules about disclosures and when those have to be provided, especially if your case is set for trial. And as much as you tell a client to do this, it's a horrible document. I don't like doing it. Clients don't like doing it. They don't like to go through their checking account records or their debit card records. But we have to, and it has to be accurate. And the worst possible thing is when a client's on the stand at trial on a financial affidavit that they threw together with all sorts of estimates, and all of a sudden their credibility is out the window because they just put $100 here, $200 there, and all of a sudden opposing counsel has done his job and said, where in your records is that $200? You don't pay for, such and such a class anymore. Your affidavit is inaccurate. And all of a sudden, your failure, my failure, to go through that financial affidavit carefully with my client has now proved to discredit her in open court. And so I've failed her in that moment by not preparing her efficiently to fill out that document as accurately as possible so that she understands the consequences if it isn't. So, in divorce especially, not every case is litigated and you're not going to face that issue. But if the case is going to get in front of the judge at some point, spend the time to make sure that those affidavits are accurate because they're verified, and you don't want to get caught in a situation where your client is not credible because they've made something up because they want to rush through the documents. And the courts, the last thing, the courts have no patience. They don't. What I've seen, and I don't know about other practitioners, is the rules are the rules are the rules. Supreme Court rules apply, and rules of civil procedure apply in divorce court, just like any other court. And if you step up there, you have to comply with the rules. And if you don't comply, come back to me when you do. So they're not patient. And, it's up to us to make sure on behalf of our clients that we're meeting those rules. So be vigilant and be aware. So that's all I have to say. Thank you.
And you said it very well, and I thank you. So we've answered a couple of the questions. I'm looking in the chat now, and I see one additional question from Madeline Tick. Is Madeline still here? I'd be happy to discuss her question.
Her question is, in keeping the court in the loop, what sorts of updates should counsels and parties be regularly providing?
And
know,
I think, go ahead. No, go
You know,
ahead.
what I've found in cases, not every case is the same. You know, there are some cases where discovery is very basic and we're exchanging income information and bank account information. Some are retirement account statements, maybe a house appraisal. But there's other cases that involve business interests, stock options, you know, self-employed people who, you know, when we're talking about financial statements, corporate tax returns, where the discovery becomes voluminous. And what I've found in those voluminous discovery cases is I keep my inventory and I update it so that every time I go to court, I have that updated inventory. So I know immediately, Judge, last week I got this, but I still need this. So, and judges have found it very helpful to the extent that a judge has asked me for my inventory in advance of our court appearance so that they can look at it. So it's really helpful in those very voluminous cases because someone might walk in and say, they haven't given me anything. Well, Judge, look, here's my inventory. You know, I've given them, because everything's spade stamped, I've given them 5,000 pieces of paper. And this is when I gave them this. And so it's, you know, it's very, very helpful, at least in the cases that I've dealt with in those high volume discovery matters, to, you know, to keep that Excel spreadsheet and that inventory of when things come in and when things go out. And judges really appreciate that. And you get a leg up with the judge.
And if I could add just one more thing to that, I think, actually, I'd like to add two more things as long as we have just a minute. In conjunction with what Elizabeth said, there are attorneys who will try and inundate you with meaningless and insignificant discovery compliance. And somewhere in the midst of all that discovery compliance that you have no interest in and no necessity to really have, they're going to bury something that is in compliance with what you've requested in the hopes that you're never going to see it or pay attention to it. So I think it's very important, like Elizabeth said, inventory, not just the discovery that you send out, inventory what came in. And keep a list so that you know if somebody tells you that when I sent you 4,000 pages of discovery compliance last month, this was in there. Well, if it's in there and you properly inventory the receipt of that discovery compliance, you're going to know it's in there. And the last tip I'd like to give is a thought that I've had throughout my career. It's not necessarily only what a client or another attorney did do, it's what they didn't do. So if somebody sends you discovery compliance and you've received all these volumes of discovery, they've complied with potentially with what you've asked for. But what didn't they provide? What didn't they do? And it's, you know, it's a theory that also applies to cross-examination, but that's for another day. I think you have to look at these things carefully. I think that they have to be inventoried. And as soon as you get discovery compliance, if there's something that you've requested that's not in there, let them know right away. Don't hold back. Don't wait until the deadline is upon you. Get them a 201K letter immediately. But you can also pick up the phone and call the other lawyer and say, I got your discovery. It doesn't have certain things in it. Will you comply with it and send me those things? You can always follow it up with a letter or an email confirming your conversation. But we have to remember, we're kind of all in this together. We're practicing law in the domestic relations division, which as lawyers, I think we have to be civil towards one another until somebody gives you a reason not to be civil. So I think the initial phone call for compliance would go a long way, not just for your case, but for your relationship with another attorney.
Well, if there are no other questions, then I will thank our presenters.